Today's case is 56 pages long, which is pretty windy by appellate court standards, but that's because the fact pattern is worthy of its own Netflix documentary. Boiled down, this is a very dysfunctional divorce. Mom's levied a pile of false accusations against dad, such as accusing him of sexual abuse and drug addiction. And by the way, he passed his drug test. However, dad's side isn't perfect either. In 2017, the husband's friend and another accomplice tried to kidnap the wife. Now, thankfully, neighbors intervened and stopped it from going any further. And yes, that's the friend's mugshot. So anyways, as you can imagine, he's arrested. Bail set at $1 million for ag kidnapping. And the husband, who swears up and down that he knows nothing about the alleged plot, pays the $1 million bond.
That's suspicious. That's weird.
Now, in case you're wondering, the gentleman is still awaiting trial, and it appears his bond was revoked in 2019. I don't know why. But regardless of what dad did or did not know, mom uses the single attack as her basis to seek relocation with the child to California. But the judge denies it, and she appeals. Now, the appellate court affirms, but goes into very great and specific detail about why they are denying it, and it has a lot to do with how standards of review work on appellate cases. But before we can do that, we have to take a little bit of a detour here. The appellate court entertains a novel theory raised by mom on her appeal, namely that the revised 609.2 eliminated the burden of proof and instead only requires best interests. Now, to mom's credit, the appellate court acknowledges the ISBA sort of messed up when they revised the statute, but still shoots down the unique theory anyways, using some very classical wit. Respondents' view that there is no burden of proof is simply unworkable. The trial court is charged with determining the child's best interests in light of the factors in section 609.2 subparagraph G. The question is how the court does that. If there is no burden of proof, then there is neither a burden of producing evidence on the relevant factors nor a burden of persuading the finder of fact that the relevant factors are proved. If that is the case, then under respondents' view, the court is expected to somehow formulate a determination of the child's best interests, much like Athena springing fully formed from the brow of Zeus. Pretty clever. So the standard of proof stays on the party seeking relocation, regardless of the ISBA's omission, in the newer version of the IMDMA. From there, the court goes on to explain how a standard of review works. And for those sort of new to this, standards of review is best summed up crudely as follows. How big of a mistake must be made for the appellate court to intervene? Now, some things like trying to figure out what a law means require what's called de novo. Basically, the appellate court decides without considering anything that the trial court did what the law should mean, and that's the lowest standard. The highest standard, however, is abuse of discretion, best summed up as no judge would have ever come to that conclusion. Now, for relocation, the standard review is actually sort of twofold. That the judgment is clearly against the manifest weight of the evidence, and two, that it appears a manifest injustice has occurred. Relocation cases and appeals are very difficult because each person's reason for leaving is often very different. So much so that the appellate court suggests it might not even be possible in some circumstances to compare the holding of one relocation case to another. Here the appellate court says, yes, the attack by the husband's friend was a major factor, but it's not the only factor. For one, dad was very much involved in the child's life, and mom's request was kind of a shoot from the hip approach. For example, she didn't have a job offer in hand. It appears she didn't even research the educational opportunities for the child, and the court was concerned that if she were allowed to leave, at least based on what's happened up until that point, she might be tempted to keep the kid away from dad, and that might be the last time that he would ever see the child again. It's crucial to understand that the appellate court doesn't reweigh the evidence on a manifest weight, manifest injustice standard to see if they would have scored it differently. They note the Illinois Supreme Court requires that the appellate courts looked at really three things prior to deciding whether they should reverse something. Identify what evidence the court's decision was clearly and manifestly against, what manifest injustice it was seeking to avert, or why suspension of the strong and compelling presumption in favor of the trial court's decision was warranted. Anyways, that's all I have. Thanks for watching.